Hi, Namaste everyone. I am Vittala Rao, Legal and Management Consultant in Bangalore. Today I will take you through the Industrial Disputes Act 1947. Gentlemen and ladies, this act piece of legislation is extremely important for anyone who works in any establishment. And this is one of the pieces of legislation which has substantially interpreted by various courts of law, and it has been very useful for each and every one. Hence, I will take you through in detail. Let us go through this. First of all, the objectives and reasons of this act is that it's a investigation and settlement of industrial disputes and other related purposes. So let us be very clear. Investigation and settlement of industrial dispute. So this is the objective and reasons of this particular legislation. If we see the Industrial Disputes Act, it has got almost about 7 chapters. It has definitions, authorities under the Act, notice of change, I will tell you, grievance settlement authorities, reference to disputes, conciliation, tribunals, procedures, importantly strikes and lockouts, and most importantly the layoff and retrenchment and special pertaining to layoff, retrenchment and closure provisions and unfair labor practices, penalties, etc. So this I will take you through one by one. First chapter, let us see the definition. I am going to concentrate here on 4 definitions: industry, workman and industrial dispute and wage, because the other definitions will be explained to you at the appropriate time when we touch the chapters. So we will go through the definition one by one. Now first let us take the definition of industry. Industry means what it says is a business or a trade, undertaking, manufacture, calling of employees, includes calling, service, employment, handicraft, industrial occupation and avocation of workmen. This is a very, very broad based definition under section 2J. Now there are some modifications sized to this definition that also we will discuss with you. We will take it forward. Now supposing we take the definition of industry, there are various interpretations by the Supreme Court of India. From 1953 to 1962, the definition was only industry and exclusive of hospitals and service sector. It was a very closed definition in this interpretation. Industry means only industries. So we will not worry about the service sector, we will not about the hospital sectors. And second phase of definite judgments came between 1963 to 1978. Then they give a narrow meaning, reversing the earlier judgments. They said no, it's not correct. Everyone must be included here, whether it's service sector or hospital sector or any sector must be included in the definition. This is the second phase of interpretation of judges. But in 1978, a very, very landmarking judgment came from Supreme Court of India in the case of Bidpudi versus Rajappa. Now this has been a landmark judgment. This is a very, very beautifully written judgment by Justice Krishna Iyer, and he has given a very, very vast coverage of this industry, which is even today it holds good. That is the kind of thing. Let us see one by one. In short, what it says is that a systematic activity in an establishment, and it is carried on by the cooperation of employees engaged by the establishment. Profit or no profit is not the consideration, and it is establishment work is carried on with the mutual cooperation of employees, etc. So this is a very broad definition given. Then it has got a lot of implications in this manner. In simple words, as I told you already, it has got systematic activity organized by cooperation between employers and employee, production or service, distribution of goods or services, whatever it is. Then absence of productive motive and gainful objective is irrelevant here. The true focus is functional and decisive. Now I will take you through the piece of what are the consequences of it. The consequences are professions, clubs, education institutions, cooperatives, research institutions and charitable institutions and all the kindred adventures, they fulfill tests and they cannot be exempted from the scope of definition. It means that they are also treated to be industry in this meaning. Only restricted category of professions, club, cooperative and gurukulas have been exempted. There is only for a very small this one. It means that a charitable institution engaged, but they are not engaging employees, there is no payment of salary by them, hence it is not an industry. And profession, like take for instance an advocate office. An advocate office is run by one person predominantly. The entire office is run by one person, hence it can't be called as an industry. Some exceptions have been made. Now here, on account of this definition of interpretation by the Supreme Court of India, the government thought we should amend the definition of 2J and we should restrict it. Again, they were not happy with the judgment of Supreme Court and they said we will exclude the activities like hospitals, education institutions, research institutions and other things, will remove it. That's the kind of thing, and hence they amended the definition of industry in section 2J and it has notified, but the effective date is not yet notified till today. Though the amendment took place in 1982, till now the amendment has not brought into force. Hence the Supreme Court of India in BWS Rajapaya still holds good as on today. It is a valid piece of document. I will just explain you some small experts of the judgment of Supreme Court. If you got time, if you get the judgment, please go through this. This is a wonderfully written judgment. It is a very mind-boggling judgment. Now I will not go through this immediately. First of all, I will only say an industry cannot exist without cooperative endeavor between employer and employee. This is the amazing basic factor of determining what is an industry. And if you have to look into education institution also, what it says, the education, if you look at it from the angle of the act, it is viewed ingredient of education are fulfilled. Education is therefore industry and nothing can stand in the way. Though the education institutions, okay, they run for the profitability thing and all that are not without profitability, but the thing is, it is an industry because it engages sets of people, teaching staff and non-teaching staff. Non-teaching staff, again, they receive the salary, etc., etc. Hence, it is an industry. That is the kind of thing has, right? And under the sense of value required by traditional act, conservative as the modern and progressive social teaching and teachings are no doubt assigned high place of honor and obviously necessary and desirable that teaching and teachers should receive respect that is due to them. Hence, they said we will not include here. And most important thing is that people in the education, certain philanthropical devotions based establishment, not wages, they don't work for wages, but for sharing the cause and fulfillment, and then the industry is not an industrial at all. Take for instance in Bangalore, we have got Satya Sai Baba Hospital. It's one of the largest hospital, and this is one of the hospital in the entire world where it is no billing at all, absolutely no billing. It means that it's totally free, and the people who come there, including the ward boys and nurses, sisters, doctors, surgeons, everyone, they come to render their services, and they don't take a single paisa salary. So hence it is not an industry. Hence, this gentlemen, this is the word of definition of industry. You must always bear it in mind. These are the small bit of principles. Organized by employee, cooperation between employer and employee, production or distribution of goods or services. It is separated in Red Cross Society versus Punjab Haryana held even Red Cross Society is squarely falls under the definition of industry. Similarly, I can take you the various certain case laws. Irrigation department is an industry. Then Education service, not an industry, but it is the mother of industries. Look at the interpretation by one of the High Court, Ramakrishna versus Samrat Ashok Technical Institute. A children education institution. Here, the society is not an industry because it's purely a children home and nothing, no question of employees and there is no question of paying salary to anyone. It is purely a society, hence it is not a industry. So hence this way he said, take for example now Sansthan, is a philanthropical idea, but it cannot be forgotten that the workers working there have not exactly come for rendering the services. These employees cannot be called as shishyas or devotees, hence the Sansthan is an industry. I told you already, anybody working for remuneration employed by an establishment ultimately comes to under the definition of industry. Here also I'll take the example, for instance, CMT Institute versus State Labour Commission, Karnataka High Court has held the same thing. And let us look at the definition of interpretation of industry in Tirumala Tirupati Devasthana versus Commission of Labour. Here, as you know, in Tirupati, not only temple and all that, but supplementing you got a huge residential accommodation. Somebody has to take care of the electrical maintenance, water supply maintenance, building of maintenance. For all these things, the temple has to engage people. Once they engage people and pay the salary, then it falls under the definition of workman. Take the example Ramakrishna Mission. No, it is not an industry because of the area thing. Take the example All India Radio on Doordarshan. They said that they also make profit because of various advertisement, etc., etc. Hence, it is called an industry. So, gentlemen, this is how the classification definition of industry has been made. A systematic activity, there exists employee relationship, any activity, commercial, spiritual, hospitality, any service. Now, this definition has been held to be valid till today. In fact, for information, in the upcoming Labour Code, definition of industry, they have included the same definition as is mentioned in this judgment. So this is a very important judgment. Please bear it in mind. Okay, next section, what we are going to discuss is the workman. Who is a workman in the industry? In simple words, I can say that a person who is not engaged in supervisory and managerial role is an industry. In simple terms, though the definition you can read it, it's a very detailed explanation is given. I can tell you in simple words, a person who is not engaged in supervisory role, then he is a workman. Simple. If a person is working, but he doesn't have any subordinates to work under him, then he is not a workman. He is a workman. Supposing a person he is there and he has got subordinates to work under him, then he is out of the definition of workman. In short, this is the explanation given under this. And of course, there are some, if certain supervisors getting less than 10,000 rupees today, then he falls in the definition of workman. Of course, that is not practically and possible because no supervisor will get less than 10,000 rupees. And in code, they have made it 18,000 rupees. Even then, it doesn't matter. It means that all the supervisory staff are out of the... To determine who is the supervisor, the simple test is that supervision, management, control of people. That is the main thing. So, in simple words, this we have to bear it in mind, friends, because this is very important for you people who work in any establishment. You get a doubt. Oh, he is a manager. Is a workman or not a workman? You get it out. Then apply this principle. You have to apply this principle. Whether the manager has got subordinates, whether he really controls set of people, whether he exercises authority over them, that is the deciding factor. If that is yes, then he is not a workman. If there is no, then even though he is a manager, he becomes a workman under the ID Act. So this is the definition of workman. Same thing has been included in the IR code also. Same definition, no changes at all. And of course, it includes industrial dispute rights. Supposing a person has been dismissed from the company or terminated from the company and he wants to raise a dispute, then for that purpose he is deemed to be a workman. He is deemed to be a workman. Only for that purpose he is deemed to be a workman. That's the only thing. And of course, naturally, the defense force and police force and prison services are excluded from the definition of workman. Now, that's why I told you, important criteria. Employed in industry is important. Nature of work, this you have to thoroughly examine it. Roles and responsibilities, you have to examine it. For the production is that a person dismissed and retrenched, he will also be workman under the Act. So this is very important. This formula you should bear it in mind whenever a situation comes. Should I dismiss him without conducting inquiry, or should I not dismiss him without conducting inquiry? Is a question. So then at the other time you have to answer these parameters and decide if he is a workman, you have to follow everything. If he is not a workman, that is a different issue altogether. So they're very important. Please bear it in mind, this one. For I will see you some examples. For instance, a pilot in an airline, he is held to be a workman. He may get about 8 lakh salary per month or 10 lakh salary per month. That is not the criteria, because the pilot is nothing but a driver in the air. That's all. There is no difference. He doesn't supervise. He doesn't manage. In other interesting cases, it was argued, he has to supervise the crew in the aircraft. He has to manage the crew in the aircraft. The High Court said, nothing doing. That's the only incidental job. What is the predominant work? Predominant work is to drive the aircraft. So hence he is a workman. So similarly, some examples of a cameraman. He is not a workman because the technical knowledge he has got. A teacher is not a workman. This is very, very clear. Please bear it. Even Supreme Court also has very clearly. What says a teaching is not unskilled, skilled or technically managed. It is not a mechanical. It is a process of what you call sharing the knowledge. A teacher shares the knowledge to teachers. It means he transmits his knowledge to students. Hence, he is out of the definition of workman. This is a very, very normal thing what has been held here. Similarly, a priest in a temple, he is not what he did, he propitiates God on your behalf whenever you go to temple. So he is not a worker in under the definition. And if a manager in a particular area, he has got powers to dismiss, appoint, and all these things, then it doesn't fall in the definition of workman. A private secretary of a MD, he or she is a workman because they don't have any subordinates to work, they don't manage it. Take the example of software engineer in IT company. Many of you may be in software companies. A software engineer, he is not doing a supervisory job. A software engineer works on his own like anybody else. Hence, till today, the definition has not been altered. This principle has not been altered. Hence, that's why we see a number of cases also in various courts involving software engineers. Hence, a software engineer is considered as a workman. Of course, there are all many decided cases. So what I am showing to you, we can go through at leisure. An important thing is, even the Supreme Court of held that in the case of ESI, in the ESI Corporation, doctors are not workmen. This is a very, very significant decision by the Supreme Court in 2013. They said doctors are not workmen under the definition of ID Act. So here the important thing is, just keep it in mind, he has got powers to appoint persons, dismiss, punish, direction and supervision of job. This is most important. Direction and supervision of carried out by the subordinates, and power to sanction leave, control, etc., and give reports against the company, against the management for any kind of disciplinary activities, all these things. Then he maintains production, demands production, manages. Then these are the set of formula to decide who is a workman. So please bear it in mind. Whenever a situation comes, you have to take care of this. Now these are the few examples I have tabulated. Who is a workman, who is not a workman. You can just go through it. You just take accountant, no supervisory responsibilities, he is a workman. An accounts officer, clerical nature of work, nothing. Like that, these are the set of table I have made. And look at the not workman. Here the predominant thing is supervisory functions everywhere. A doctor, as I told you already, legal assistants. Legal assistant is, he does some creativity job. Legal assistant, interpretation of law, hence he is not considered as a and senior engineer and medical officer. Like this, any profession as a matter, any question comes, you have to apply these principles to test whether he is a workman or not a workman. This is the most important thing. Now next we will come to the definition of industrial disputes. It is a very, very simple definition. Any dispute or difference between the management and the worker, employers and employees, between employees and employers, employers and employees, and of any person, this is the industrial dispute. It's a very, very simple definition. So here, analysis, if we make it, it says that simple word, it should be a dispute or a difference. Otherwise, there cannot be any dispute. Supposing a worker makes a demand, the management says, no, I will not give a demand, so there is a difference of opinion, that forms a dispute. Suppose somebody is given a promotion and then he is not given a promotion, and the union questions why promotion is not given, the point of difference comes, that is a dispute. Like these are the few examples, and he connected with the dispute, connected with the employment. That's very important. So here, one more important thing is in this dispute here, it should be in plurality, in the sense that an individual worker cannot raise an industrial dispute in an organization, because that is taken care of very well in here, because it should be in plurality. It means that even if individual has to raise a dispute, he has to go through the union. The union should pass a resolution, and union should raise the dispute on his behalf. An individual worker cannot go to the labor department, tribunal and raise a dispute individually, because individual disputes are totally discouraged by the legislation, because otherwise it will lead it to terrible industrialization chaoses. So any dispute should be sponsored by a trade union, and trade union should fight the dispute on their favor. That's the kind of thing. That's very important here. So here also, same thing I told you in this case, Sagandi versus Sagandi, Supreme Court has said, a dispute between an employer and single employee cannot by itself a dispute. I told you already, these are a few examples. And similarly, in oxygen versus workmen, in Supreme Court has said the same thing. You can have a look at it. And one question came, can the union raise a dispute on behalf of non-workmen in a establishment? Because the definition of dispute is a last word, any person, it says that. The union took up this word of any person, and then they contended that the question that can the union sponsor the dispute related to a non-workman in it. For this establishment, what happened is that is a case in the Kerala Workers State Electricity Board case. Here what happened, the non-workman means the above level of workmen called supervisory managers staff in the board. They had introduced a promotion scheme. Earlier the promotion scheme was based on the internal promotions. It means that people who are at the lower rank can go up to the level of higher level based on criteria, etc., etc. But here case B, what they did was that they said that they removed that clause. They said they will recruit and promote in a different way. So the union got agitated, because union felt that they have lost the opportunity of getting the promotion for their members. Then they raised a dispute on behalf of the non-workman. So this is the kind of thing. Of course, there are very rare cases, but as a matter of interest, I can tell you that the union can raise a dispute of any reason. Of course, they should be the same establishment. That is the criteria. But only they don't have any rights to go on strike or whatever. The non-workman, they can't do anything. Only the union can question their authority. That's the only thing. So this is a limited application of mine. Just keep it in mind. This is also possible. Now under the section 2A, I told you already, if a person has been dismissed from services, terminated from services, or retrenched from services, he can raise an individual dispute because he is not in the employment. But that taken as industrial disputes, because individual who is dismissed can raise an industrial dispute. This need not be by the union. He himself can raise a dispute. That's the only small exceptions have been made. So what's the nature of disputes? Normal thing what we have seen is that dismissal, retrenchment, and then revision of wages, revision of salaries, and non-compliance of provisions of law in respect of payment of minimum wages, bonus, any change in customary practices. Supposing I got a set of practices which I want to change, and that can be a matter of dispute. All these things will happen, and disciplinary action, like for instance dismissals and then demotions and withholding increments. This all they can be matter of disputes, but the only thing is everything dispute should be sponsored by the trade union, not by the individual. So this is extremely important. Now next definition what I want to talk to you is about the average pay, because this is required for many applications. Average pay here means the average pay paid to him during the 3 calendar months. It means that average pay includes a gross salary. What is the gross salary drawing during the previous 3 months? That is called as average pay. This is for various purposes required, which I will tell you in the subsequent presentation. Here, very important, there are 3 types of wages. One is the layoff compensation. That's layoff compensation, but layoff compensation is based on the basic and the day allowance allowance, 50% of that. That is one thing. Whereas the retrenchment compensation is on the average pay. I told you already in previous slide, average pay. So here the gross salary is taken, whereas layoff compensation is only basic DA and 50% of that. Retrenchment compensation, closure compensation, they are all gross salary. Similarly, 1 month's salary in lieu of notice, again it's a gross salary. All these things. And furthermore, the retrenchment compensation is a condition precedent. It means that when you retrench a person, on the same day you have to pay the compensation. If you don't delay even for 1 day, the retrenchment is bad in law. Whereas layoff compensation is not a condition precedent. You can lay off, you can pay at the wage period, at the whatever the designated day of payment, you can pay on that day. Similarly, closure compensation also, it's not a condition precedent. Afterwards you can pay. So this is the only thing. Just to keep it in mind, this one. And here, particularly retrenchment compensation, they should, and notice pay, there should not be even 1 rupee shortage, because there are many decisions were taking place. In one case, the shortage was only 5 rupees, but the court said nothing related, technical error, so action is bad, you take him back to work and matter is left across. So this is one thing. So just keep it in mind, this is exactly important. And what does it PF and ESI call for? Layoff compensation, no ESI, no ESI contribution you have to, but no PF contribution. Whereas retrenchment compensation, no PF, no ESI. Closure compensation, no PF, no ESI. 1 month notice pay, no PF, no ESI. 1 month say pay at the time of dismissal or termination, here also no PF, no this one. And filing approval application section 33B, I will explain to you later, that also doesn't attract PF, ESI. So just remember, layoff compensation they make, ESI contribution is mandated, but PF is not applicable anywhere. Just keep it in mind. Definition of continuous service, they have been defined for the purpose of payment of compensation under Chapter 5B and Chapter 5A. Here 240 days. 240 days is actual work days by him, previous 12 calendar months. How many days is work? Some exceptions are there. Exceptions means interruption due to sickness, unauthorized leave, or accident, or strike which is not illegal, lockout which is not illegal, a cessation of work which is not due to fault on the part of the workman, shall take as day's work. That's all the purpose. So 240 days is a very, very important thing for various applications, because even in the courts of law, if a person has not worked for 240 previous days, he cannot raise a dispute at all. It will vanish. So this you must bear it in mind. The precondition for a valid dispute is 240 days work by him during the preceding 12 months. Now we come to bilateral steps of resolution of disputes. First of all, we have got works committee. Works committee consists of the representation of workers and the management, and they discuss on day-to-day, periodically they have to meet once in 3 months. They discuss all the shop floor issues or any other type of grievances they have. It's only to promote a bilateral discussion so the problems can be settled there itself. So this is one of the step of this one, and this has been functioning well some of the establishments also. Next, what is the conciliation? This is the conciliatory step. The government comes in the picture. Here we have got assistant labor commissioner, assistant labor commissioner, labor officer, deputy, they are all designated as conciliation officers to see the dispute. There is a board of conciliation. Here the important thing is that some important issues comes between, let us say, the dispute involved in 2-3 different states, or multiple disputes are there. Then the government can constitute a board of conciliation under section 5A, and this can, but this is not that very popular in the entire thing. Now here also courts of inquiry. Supposing the government feels that a particular dispute has to be inquired in detail to arrive at a conclusion whether dispute or not a dispute, a court of inquiry can be appointed. To the inquiry committee will go into details in depth, find out whether there is a genuine reason, substantial reason for raising a dispute or no, depending on the individual. This is also not very significantly proper. Next is the labor court, friends. Labor court, of course, you know, it is headed by single judge, and here also a lot of importance has been given for the appointment of a judge in the labor court. You see, he has been a judge of high court, and at least he has a period of not less than 3 years been a district judge or a additional district judge. Because here what happens is that the government has given a lot of importance for the judge, because the labor disputes are extremely important, because the labor laws are based on equity principles. It's all courts of equity. It means that a judge has to have a competency of deeply analyzing the entire circumstances of the workman and the management and complete decision. It's not just mere interpretation of law and then say yes or no. So for this purpose, the keeping in mind the legislation I have proposed, the judge must be in this particular level, which is extremely important. And similarly, tribunals also on the same lines. Here also the same quality of judge has been nominated, and national tribunal consists of only one person. Of course, there is some changes in the industrial IR code which is coming up. Now labor courts are removed, and industrial tribunals are replaced by a team of 3 people, not 1. Right now we have got 1, but in IR code there are a set of 3 people, 2 judicial members and 1 non-judicial member shall form the industrial tribunal under the new code whenever it comes to force. This is the thing. Now national tribunals in case of national interest, take for instance Indian Railways, shipping, cement industry, or core industry, where all the central government controlled industries, then they can set up a national tribunal, because in the state industrial tribunal cannot handle this, they are barred from this. Hence for this purpose it is a national thing. Then the powers of conciliation. What are the powers of conciliation officer? In a public utility services, if he apprehends there exists a dispute, he can issue notice and start conciliation. Take for instance our local transport or local telephone exchanges or anything. But they said, we say we'll go on strike after 15 days or whatever it is they say, or we're lighting the strike tomorrow we are going to strike. Then he apprehends certain thing for utility services, then immediately he can send notices and call the parties for a discussion to consider the matter. So there it starts it. Now somebody usually has served a notice, again he can involve, and supposing the management refers it, the issue for a conciliation officer, he can call for notices and involve, and he has got all powers of a civil court in calling the persons as witnesses, to call any documents needed to investigate the dispute. He can do. His main job is to see that whether he can effectively conciliate the dispute between the parties and bring it a settlement. That's the only thing. That's very important. That's only his part. It means that he must understand both the parties. He must understand the issues thereon. Then he should try to persuade both parties whether he can bring a settlement. That is only his responsibilities. But he had no power, he has no powers to pass any orders like a court. He has no authority. He can only recommend and against quality. If the people do not agree, it's a different issue. But he doesn't have any powers or authority to pass any order in favor of anybody. That's the only thing. Of course, Similarly, in the board, court and labor court and tribunal, of course, naturally, as you know, these are all the regular courts. They have got all powers entrusted to a judge in any court of law in summoning witnesses, taking the evidences on oath, and issue warrants. All these things, powers they have, and they can do that. So, within the meaning of every investigation thereof, you will have a judicial proceeding within the meaning of section 193 and 128 of Indian Penal Code. So this is the job of this one. Now here, next we will come to notice of change, section 9A. Friends, this is a very important piece of provision. Notice of change. Supposing the management wants to modernize the mission, supposing management want to expand the unit and automate the entire thing, and they want to enhance the productivity of people, they want to introduce some kind of automation system, or they want to shift a portion of the shop floor to another subsequent thing. Any change in this one, now all these things falls here, notice of change, because this amounts to a alteration of service condition. Today I am working here, that's my condition. Tomorrow if you ask me to go to the next floor and start working on a different machine, is a change in service conditions. So here what happens, if the management wants to carry out any change in service conditions, they have to mandatorily give a notice under section 9A 21 days earlier and start with that. So actually friends, this has become major bottleneck for our globalization and global competitions, because as you know, in 1991 India was thrown open to the globe for various international competitions. The company had to modernize the plant. The company had to technically give expertise to the workmen. They have to train them. They have to understand. They have to adjust to new circumstances, adjust for rationalization, change in methods, change in system, everything. But that has become major bottleneck because of this section 9A. Of course, all of us are propagating to remove this section, but so far the government has not helped us, and even today the same section carries on. Even under the new code also same thing retained, but this is one thing. So this is one thing which is a bottleneck, which you have to keep in mind. Only solution is that you have to take the people into confidence, make them agree, then effect the change, then this question will not arise. Of course, these are the schedules. What are the changes? Wages, contribution paid or payable, compensatory other allowances, leave hours and rest interval, leave with wages and holidays, starting, ordering, discontinuing shift working other than what is provided in standing orders, classification of grades, withdrawal of customary concession and privileges and changeover. Let us say today I am giving free lunch to everybody. That is the condition of service. Tomorrow I say that no, I can't give free meals, I am going to charge you 2 rupees per meal. There is a change in service condition. So this comes there. Then in such cases you have to talk to people, find out, and then make them agree, come to an understanding, then effect the change. Then there is no problem. This is simple words. So this is a kind of thing. Then rationalization, standardization, improvement of plant, which likely to lead to retrenchment of workmen. Suppose you modernize the machines, modernize the system, it leads to retrenchment, means it is a section 9A violation. So these things have to be kept in mind. These are the schedules. So these have to keep it in mind before affecting any change. This is extremely important, friends. Now here, of course, here there is relief given. See, trade unions are no way superior, because what happens? First of all, the trade union leaders, they are employees of the organization first. They are employees. Union status is next. Hence, they are not away from the application of any kind of disciplinary actions or anything. They are out of the purview. You hear also, a trade union leader can be transferred from one place to another place. It is actually conditions agreed. It is the terms of appointment. In the standing orders is mentioned that it can be transferred. A trade union leader cannot say it amounts to change in service condition because I happen to be a trade union leader. So this is one case in Secretary T.N. arrested in accounts case subordinate in Madras High Court. And supposing, let's say for instance, due to shortage of power, the government says you please let us have staggered weekly off. Instead of all the thing on Sunday, we'll have staggered weekly off. That cannot be questioned because that is imposed by the government on account of this. Hence, it doesn't call for any notice under Section 88. So, there are some few examples. So, here also in case of transfer of establishments, in case of transfer establishments and then acquisitions by some other people, some other employer, at that time what happens is that here also change in submission comes because he is joining a new employer, and supposing there are any changes in the service, like for instance in salary structure or benefit structure, if the new employer says new changes, it has to be under an agreement or understanding. Otherwise, what happens? The Section 9A comes in the picture. Hence, that's what we say, that in case of acquisitions and mergers, we say the terms and conditions of service of employees shall remain unchanged. That's exactly what normally we mean and then affect it. If there is a change, then the notice has to be given, or you have to enter into an agreement, a settlement with the concerned workman. So this is very, very clear. You have to keep it in mind. And of course, this is only a Section 7B, I told you already, in case of public interest like power supply, power cut and all that. If they do it, the exemptions are available. And another step is what is called grievance redressal machinery under Section 9C. Here also, if any establishment employing 20 or more workmen, they have to have grievance settlement machinery. It means that there should be a combination. There is a committee of 3 workmen and 3 management representatives, and any worker has got a grievance, he can bring it before the committee. The committee shall go into details, deliberate it, and take a decision whether the grievance is real, genuine, correct, not correct, justified, unjustified, whatever it is. Then they record accordingly and then give a judgment whether the grievance is correct or not. The agreed workman can appeal to the company head. Like for instance, he can make an appeal that the grievance settlement machinery have conducted these deliberations. The decision is not in my favor, hence I request you to consider. He can make an appeal to the chairman or the MD of a company, not beyond that. That's all. Supposing if they are still unsatisfied, then he can approach the union for raise the dispute. That too, the union has to have a general body meeting, pass a resolution, then only they can take it. Of course, this grievance settlement machinery, at the moment it is not mandatory. If the company has got a systematic grievance settlement procedure, then this is not required. But in the new code which is coming up now, it has been made compulsory. Even though you have got a procedure or not, you have to have a grievance settlement machinery, and that has got more cascading effect under the new code. For information, the ID Act, this is a kind of thing. Then what happens? Let us say, for instance, the dispute is raised. The matter goes to the conciliation. The conciliation also sits and discusses and tries to arrive at a settlement between the parties. He is not able to succeed. Then what happens? The dispute has to be referred for adjudication by the government, because that is the only thing. Whether it is in favor of management or in favor of union, the dispute has to be referred to. This is exactly what it talks about. Dispute to boards, inter-labor courts or industry tribunal under Section 10. Under Section 10, the government has got powers to refer the dispute to labor court or tribunals, whatever it is, with a reasoning, with a what you call point of reference. Supposing let's say the question is charter demands. Workers are demanding X amount. The point of reference can be, or the union is justified in putting a charter demand, demanding so and so money on the management. If so, what is it? What is the relief? This is question, the reference point, and then they refer to the industrial tribunal. This is exactly what is happening under Section 10 of the ID Act. This is reference. Summary of same thing. What I explained to you, I have mentioned the same thing, and this is mandatory to be followed. And only thing is, in case of the government has no justification to say no. If they have to say no for reference, they have to go with a reason. It's not that easy, and it should not. It is not an administrative function in the sense that okay, failure report has come, automatically I refer it. It is not done. But one thing is they can't use the judgment. They can't use the judgment, and before they refer, they can always call the parties once again for discussion, and then ultimately take a difference for reference. So this is the only thing. Makes a must record its reasons thereof and communicates. That's the only thing you do. It means that actually when the case is referred, the government also will prepare a note and give it to both the parties. After what are the reasons for them to refer or not to refer the dispute to the parties, and if they want, the parties can go to High Court and challenge the same thing. This is exactly the decided cases. So here also the even a rival union, let's say there are 2 unions or 3 unions in a company, and then 2 unions or little more have got more membership, and then they have signed a settlement with the management. Another rival union, they have a small membership. Still they can raise a dispute. And that dispute also can be referred to the adjudication. That's exactly what is TVS Suzuki Limited was set up in 1993 has been held. So at the same time, what happens when the dispute is, supposing there is a strike or a lockout, the government has got powers to prohibit the continuance of strike or a lockout, because the intention is to maintain the industrial relations in a particular area, particular belt. That's important. From that point of view, the government shall prohibit the strike or a lockout at the time of reference. So this is not separate, it is a simultaneous action. Then this is exactly what it means here. Now here also there are voluntary reference. Supposing the matter is before the conciliation of the crisis level base. Then if both parties say, okay sir, we will, instead of referring the matter to conciliation, why not we appoint an arbitrator and refer the matter for arbitration? Oh, this is an excellent step, because arbitration advantages are, it is a time approach, in the sense that both parties can decide. The dispute can be settled within a period of 6 months. It can be settled within a period of 8 months or 1 year. You can put a time frame and appointment order. The proceeding before arbitration is same as what happens in a court of law, like tribunal or labor court. Then the important thing is that the fastness will be there. Today, if the matter is referred without arbitration, it goes for a number of years. There are many disputes pending before courts for 4 years, 5 years, 6 years. It is pending. But in arbitration, what happens? There is self-contained provision. You can limit the time of decision of the case, either this way or that way. You can finish off. This is also built in under voluntary arbitration under section 10A. And of course, this also I told you that prohibition of strike. Then of course the labor court and tribunals and I got appropriate here they got up on the right to go into appropriate relief to the discharge and dismissal of workman. The thing is that supposing the punishment awarded to a person by the management is consciously very grave and obnoxious, in the sense that it is not proportioned to the misconduct. Let us say, for instance, he has remained absent for, let us say, couple of days, or let us say 15 days or 20 days absented, and then if you dismiss him, what happens? The punishment of dismissal for an absence of 20 or 25 days is abnormally high, disproportionate. So then at that time, under this particular section, section 11A, the courts have got powers to go in details and then award lesser punishment than the dismissals. That is the kind of thing. So this is a very given power, but this power of this one has to be exercised by the court in a very, very cautious manner. Because the here the section says that the labor courts or tribunals, if the inquiry is conducted by the company is fair, reasonable, and in line with the principles of natural justice, and the order has been passed by the management, if it is all prescribed by all things, normally the court should not interfere in the punishment. They can interfere only in case if they feel that it is very harsh punishment, then only they can interfere, otherwise they cannot. So this is the crux of the section here, and this is very important. And for instance, here also there are many changes have taken place. Earlier, people used to say theft means theft, so he is dismissed, he is to be dismissed. And sometimes the judiciary changed their mind. No, theft means was, say, for a theft of 10 rupee component, would you remove the person from the employment? Should he cost his life just for theft of 20 rupees? So it's not correct. That's the kind of thing. But now what happened? The judiciary has changed their mindset. He said, no, a theft means a theft. It means that it is a dishonesty on the part of him. So it is a fraud against him. The company has lost confidence on him because he has committed this crime. Hence it is valid. Those are the kind of thing. But in some cases they are very, very clear. For instance, though it is an assault case on a manager, abusive words on a manager, or trying to get away or superior, and willfully giving slowdown productions. So these segregations, they say that okay, dismissal is the right thing. So it all depends on the particular case. A lot of changes are taking place. But one thing is, as far as possible, whenever you give a punishment, please give the punishment in proportion to the act of misconduct. That's very important. Exceptions are all these things. For instance, dishonesty, fraud, mischief, forgeries, assaults, all these things nowadays, in fact, the sexual harassment, all warrants dismissals and nobody can interfere. So Section 90 applications will be limited. So just keep it in mind. This is the spirit of the law. The spirit of the law is all changing. Of course, this is also that's what I have. High amount of care and caution should be exercised. The Labour Court will make invoking said discretion in replacing the dismissal order. That's what he said in Supreme Court in Develop Narcis Carities in 2014. They have said very, very clearly. And let us take the example of a night watchman. Here also, Orissa High Court. A night watchman sleeping on duty. That's a grave misconduct, because if the night watchman sleeps while on duty, then where is the question of security? So he said that dismissals are valid. So it depends on the facts and case. Suppose the bank employee, he is involved in the what is called guilty of inquiry misappropriation cases or fraud cases, then dismissal is definitely warranted. Nobody can interfere with that. So this is extremely important. These are certain things which have been here. Then under Section 17B, some relief has been given. Supposing you have dismissed a person and then he has gone to the Labour Court. The Labour Court has given the verdict in favor of the workman. The Labour Court has said this order passed by the management is not justified, hence he is ordered to be reinstated with full back wages. That is the kind of order. Then the management has got a right to go to higher authorities like Supreme Court or division bench or whatever it is. Then at that time, what is the relief to the workman is a question. So here the Section 17B has been introduced, saying that if the management appeals before the authorities, then the company has to give him, during the pendency of the appeal, the last drawn salary by him you have to pay till the disposal of the case, because some kind of relief has to be given to the family. But there is a condition. It means that if the person prove that he is not employed anywhere, he is not earning any salary, he is actually penniless, he is depending on this, then if you make out that case, then what happens? The company has to pay the last drawn wages till the appeals are finalized either before the High Court or Supreme Court, whatever it is. So this is the spirit of law under Section 17B. So this is exactly what I told you. You can always have a look at it. Now come to settlement. So I told you already how the settlement takes place. Settlement is, there are two types of settlement. The settlement can be arrived during the course of conciliation or outside conciliation. There are two types. Let us say there is a dispute. Both management and union sit together and then mutually discuss. They come to an understanding and they reduce the understanding into a form of a settlement under section 2P. Then it is called bilateral settlement. When this is called bilateral settlement, and this bilateral settlement has to be registered with the concerned conciliation officer for registration. This is called. The other thing is tripartite. The dispute is referred to the conciliation officer either by the union or by the management. The conciliation officer is able to succeed in signing the settlement with both the parties. He signs the settlement, and that is called a tripartite settlement. That is called under section 18.3 of the Act, and this is section 18.1. So this is a chart, simple chart I have made. A dispute is there. Then conciliation under section 12, it comes there. If there is settlement, then it is section 18, it comes there. A failure report, if the conciliation doesn't succeed, then failure report, then it goes to the government. The government will refer for adjudication under section 10, and then actually award is passed accordingly. But in between, I told you already that arbitration, even the conciliation is in progress. If both parties agree, okay, we will have an arbitration, then they can also go for arbitration under section 10. This is how the dispute is going to be resolved. A settlement, I told you, explained you already. There are two types of settlement, and one conciliation settlement. Here what happens in conciliation settlement, the binding effect is only on the parties to the settlement. That's very important. You must keep it in mind. Binding effect is only on the parties to the settlement, nobody else. Whereas in the course of tripartite agreement, it not only binds on all the parties and all the employees also, including the future employees. So let us say, for instance, there are 2 unions or 3 unions. You sign the settlement with a majority union under section 18.3. Then by implication of this, even this settlement shall be binding on all the people, including those unions also and those members also. It is binding. And even in new joinees, supposing next year some people join, the settlement benefit shall be applicable to them, as well as the reduction of wages, change in the wage structure. It is applicable to the new people also. So this is exactly, and there is a more binding effect. That's why, friends, normally what we encourage is that always you go for 18.3 settlement from all points of view, because it is absolutely what you call dispute-free settlement. 18.1, of course, limited aspect. So this, depending on the situation, this is how the difference is between these two things. Of course, these are some few decided cases I just explained to you on this one. So this is the binding nature I explained to you. You can have a glance through all these things. Here also, in the premier case in Kerala High Court has said, a settlement arrives in course of conciliation with a recognized measure will be binding on all the workmen, including belonging to the minority union and dissenting union. The objective is to uphold the sanctity of settlementaries, that is spirit. So this is exactly what has been held. They are very, very valid thing. Then of course, the procedure says that the settlement has to be in Form H, and this is a standard format, it has to go. And in case of bipartite, it has to be registered with authority, otherwise it will not be treated as a valid settlement. So keep it in mind, if it is a bipartite settlement, you have to get it registered with the registering authority. If it is a tripartite agreement, nothing, because you are going to sign before the conciliation himself. So that is quite valid. Now let's come to the important topic of strikes and lockouts. Now strike has been very simply, it is defined. It is a concerted action of group of workers with a common intention of doing this. With a common intention, concerted. So if one worker doesn't work, it is not a strike. If people do not work, it is not a strike. If people do not work, no, it is not a strike. A group of workmen with a concerted approach, with a concert in their mind. Let's say 10 workers join together. They say, no, we will not work from today. We will not, that amounts to strike. So this is very important. This is the definition of strike. That's why it is called cessation of work. Number one, stop working, that is a strike. Then body of persons, that's very important. It's a body of persons. Employed in the industry, obviously. Acting in combination or concerted refusal. It's joint action, that all of us join together and go on strike. So this is the kind of thing. So it can be partial strike or a full strike, whatever it is, but a strike is a strike. Strike can be different modes also. It means that it can be sit down strike, tool down strike, pen down strike, or stay in strike, or stay out strike, whatever it is. Ultimate thing is that no work is done, it's called as a strike. So this is a very simple word. Is here also a cessation or refusal to work will come within definition. Only the concerted workmen or employed industry as defined, so on, so on, so on. In another case, State Bank of India case says that the workman in the bank struck only for a few hours for 3 days. That's all. And nowadays we have seen in the bank also, we strike work for 2 hours, we strike for 1 hour. They say, but it is a strike. It is a strike. There is no doubt. So it is held to be strike. There are innumerable examples of this kind of a strike. The question came. The union can say that, do we have a fundamental right to strike? And on Article 19.1, Article 19.1, I got liberty, everything. Do I have a right to strike? This question came. Here also, Supreme Court has very, very clearly held that a right to strike is not a fundamental right. That's a legal remedy you have. It's a legal remedy to go on strike. Maybe you have to, if you want to coerce an employer, you can go on strike, but it is not a fundamental right. That's what very clearly said. Even in case of B.R. Singh versus Union in 1989, Justice Amadi was of the view that right to strike cannot be equated to that type of fundamental right. So this you should bear it in mind. It is not a fundamental right to go on a strike. Now here also same thing. In this case also, Communist Party of India versus Bharat Kumar, and in Rangarajan versus State of Tamil Nadu, here also they have held that right to strike is not a fundamental strike, and it can be ruled out. And in fact, this judgment is very important, gentlemen, keep it in mind. Bombay Dyeing and Manufacturing, Mumbai Mazdoor Sabha in 1987. Here what happens is that a very beautiful interpretation is sharing with you. See, what they say is that supposing the workers continue to stay in strike, right? They sit inside the factory and strike. Next they go out, and they come inside, they don't work. Like this is happening. So there, the interpretation of this beautifully they have interpreted. The workers have got an implied permission to come inside to work, right? Inside to work, but not to refuse to work. Otherwise, they don't have right to come inside. It means that the company can stop them at the gate, saying that, no, you will not allow you to come inside unless you promise that you are going to work. Because it amounts to trespass. If you come inside and do not work, it amounts to trespass. So this is a very, very beautiful judgment given by Bombay Dyeing, and you can always bear it in mind. You can use this at the appropriate time whenever an occasion comes. You have to use it. This is a beautiful, wonderful judgment that I have given. Now here also, in this judgment also, the Supreme Court has very clearly had that though strike is a legitimate weapon, it should not be hastily used. That we will not encourage. That is what Supreme Court has said. We will not use it. It's not correct. And the important judgment by Syndicate Bank versus Umesh Naik, holding no work, no pay under any circumstances. He said even today that principle holds. So whether the strike can be legal, the strike can be justified, whatever the reason, the simple principle is no work, no pay. That's all. So this has been upheld by principle has been upheld by the Supreme Court in the case of Syndicate Bank versus TK Umesh Naik. Please keep it in mind always that no work, no pay. That's the standard principle, irrespective of the justification of the case. Similarly, opposite way is the lockout. Opposite way is the lockout, and here also same thing. So whatever happens here, it happens here also in case of this one. Here temporary close of place of employment, or suspension of work, or refusal by an employer to continue to employ a number of persons employed. All things amounts to the lockout. Of course, here what happens, there is some reasons why we declare lockout. If it is in arising out of an illegal strike by the workman, the lockout is normally justified. A lockout is justified if there is apprehension of danger to people and machinery of the company, then lockout is justified. And suppose you anticipate that there is going to be sabotage of the machineries, then you can declare lockout. This all depends on the circumstances. Then the lockouts are upheld by various courts. So whenever we declare lockout, we always